welcome. What is up? What is good? This begins at 1 Eastern Standard Time, which is 10 a.m. Um, Pacific. So we got about 30 minutes. So good afternoon. Um, this is the hearing. It's going to be in front of Megan Marshall, and it has everything to do with the crime scene photos. Maddie's parents went ahead and got in a temporary restraining order from anything that Moscow Police Department was putting out, a halt on that. And so that's what this is about. And then Ethan's family did join in. So this was scheduled and then rescheduled here today. So on the 28th is today. So yeah. But really quick, as we are waiting for this, I want to show you guys something that I've been looking into, which is if I was on this case, once I found out that there was text messages and what they all consisted of, I would have been asking some questions. I just want to show you what I mean by that. So take a look at this. We're going to put it side by side with something else, which is going to be one of the interviews from Dylan. And if you look at something right in here, right in this time frame. So I would have been asking questions like, hey, so was it like right after you saw the masked person that you wrote this text message? Wouldn't you? I mean, I don't know. I literally just said that court starts in 30 minutes. I don't know how people write comments like they do. You're going to have an opinion at some point about this video, so thumbs it up, thumbs it down. But if you're live chatting today, let me know where you're chatting from. I gotta laugh. Oh, shit. Oh, man. All right, let's take a look. So I just know that I would have been saying things like, did you, when you're texting, was it right after? How did this all play out with the text messages? Things like that. So since they don't really do that, I'm going to show you guys something. You guys can be your own judge, jury, all of it. Okay, right here. At approximately 4:23 a.m., she texted blank to tell her that she saw a masked suspect in their house. Now, what's the first thing that you would think of right there is at, oh God, we have the car driving away at 4:20 and some change. Okay. So if you have the car driving away at 4:20 and some change that they're saying is like the getaway car, that means you would have saw this masked person after the supposed getaway car. Okay. But what that actually helps me kind of balance here is that if we're talking about that car being potentially somebody else, if Bethany is the originator of the phone calls to say that she heard a firecracker, and just got the fuck up out of there. Okay. Bethany's able to do that. But let's break down this a little bit more and look at if you're looking at this section right here, which is okay. At 4:22 a.m., then Dylan corrected herself and said that it was at 4:23 a.m. She advised she texted blank and they conversed about someone wearing all black. And Bethany said something to the effect of, what the fuck? Why is Xana wearing all black? Dylan explained she was not certain if she had been dreaming this or if this was real. Blank explained she saw the suspect holding something she believed to be a cylinder shape, blah, blah, blah. Okay. This is the first time that you hear about first time they were talking about eyebrows is right there. Blank, she said that he was walking away from her and he looked at her, but he was walking out the sliding door and she saw him. She said she saw his eyebrows. At approximately 4:23 a.m., she texted Bethany to tell her she saw a masked suspect in their house. This is why I'm saying, like, was that like right as it's happening? Then she says Bethany responded at approximately 4:25. Now this is why this is incredible. Is because then you go look at this. And that's accurate. Okay, so when she texts her at 4:23, like he had something over his head and his mouth, remember? If you look at this, DM back to back says, Bethany, am I kidding? And then to say, Bethany says, so am I. See how it says 4:24 in 7 seconds? So that says 4:23 and 52 seconds. Okay. Well, she's looking at her phone, and it's interesting that she says that she doesn't get back to her until 4:25 after that 4:23 text. I'm curious if there was stuff, if you're using your phone and stuff's been deleted, then it wouldn't be there. So this, like, so am I. Then Dylan's saying, like, this is where a phone is going to die. Fuck, come to my room type of shit. But she wants to note that Bethany responded at approximately 4:25 a.m. telling her to come to her bedroom. So we're going to back up just a second. Let me just zoom in. So I would just be asking questions like, okay, is this like you're texting this as you're seeing things? Like, don't you think that would be one of like your most important questions? You know, again, maybe he does say it, it's just the way that it's written up. Now, this is what's interesting to me is that she advised that when she left her bedroom, she looked down the hallway to Xana's bedroom and could see her laying there. I'm going to tell you guys right now, Bethany and Hunter both say that the door was partially open and partially closed. Okay. And also Xana's head was facing to the west, like on the west side. And so if your body's like this and your head's like the west is towards Walenta. Okay. And your feet would be then, you know, and so I don't know how anybody would see anything if it was partially closed door. Just throwing that out there. Now, the other thing I want to point out is right here, because I wanted to go to right here. Dylan specifically says that the killer would have heard her calling out the names as well as physically calling them. Okay. And where she says that is right here. So if you look at this is again ISP report. She's saying that she advised around 4:00 or 4:20. She heard Kaylee singing and playing music. Now this is, remember, we all know what the body cam says. This is Dustin Blaker's interview. And so at 4:22 a.m., she confirmed she confirmed this information by looking at the texted communications on her cell phone. She has her phone out. Okay. She texted Kaylee asking her what's going on. And she advised it said 5:22 because you're in Boise. Like she was physically at her house. Okay. So she advised around 4 to 4:20 a.m. She heard Kaylee singing and playing music. She heard who she thought believed, Kaylee walking up the stairs. And Dylan advised that she heard Kaylee say someone's here. And she sounded frantic. Dylan described Kaylee's tone as somewhere between talking and yelling. It was believed it was Kaylee who was walking up the stairs with Murphy. She said she heard who she believed Kaylee running down the stairs. She advised Murphy was barking at this time. Then that's going to be all redacted. She further stated she believed it was Kaylee who was running down the stairs after she heard her say someone is here. She further explained she does not know if she actually heard this or whether she was drunk and did not actually hear any of this. And that is nothing that she had said to Noonans. None of it. She heard the footsteps of who she believed to be Kaylee. She explained all the girls wore Doc Martens. Well, that night, Maddie was wearing Doc Martens. And Maddie was actually looking for the dog. And Maddie was looking for the dog and had Doc Martens on. And one Doc Marten was found in the living room where Dylan hears music playing and dogs dancing and, and then there's one Doc Marten upstairs. Again, I don't know. Just throwing that out there. And that she believed that she was hearing Kaylee coming down the stairs wearing her Doc Martens because of the sound of the footsteps coming down the stairs. Dylan called Bethany at 4:19. Now she's looking at her phone. Okay. And my issue with that is that's incorrect. Bethany calls Dylan at 4:19. This is the correct information. Okay, so it's Bethany calls Dylan. Next. Then Xana at 4:20, Kaylee at 4:20, and then Bethany again at 4:20. Okay. Dylan advised Bethany told her about seeing fireworks. Right? Well, was it actually when Bethany called Dylan the first time to kick it all off? And this is what. Okay. But so she's looking at her phone. So she has that she called Xana and that she called Kaylee, right? She called Xana at 4:20 and Kaylee at 4:20. And actually what it is that she called, yep, you see. So she has both of those still in her phone. She's able to look at those. So what I'm trying to go with is seeing if anything has been deleted on her end that she wouldn't know of something. So what I'm trying to do is compare all that. Again, we are waiting for the court to kick it all off here in 20 minutes. So while we're doing that, then she says, then again at 4:20, boom. She said she texted Bethany a last time at 4:27 a.m. before she went to her bedroom. And I said, whoa, we got a problem. Whoa. I said, okay. So she's saying I texted Bethany at this time, the last time I texted her, and then that's when I went to her room. Okay. Well, then I go ahead and pull this out. And I'm like, okay, well, remember she's looking at her phone. I'm like, okay, well, DM to Bethany, phone is going to die. Then come to my room, run down here. DM calls Ethan. DM to BF. I'm so scared, right? BF to DM. Do you see what time this is? It's 4:24. If we're going to get into we've all thought that right between here to here, that's where that run would have happened. Okay. Actually between like all of 4:25. But if she's going to say that she's looking at her phone and she's like, this is my last text message to Bethany, and then I went down there, DM outgoing call, we don't know who to. DM outgoing Snapchat, DM outgoing message on Snapchat, DM calls Kaylee. There are no text messages at 4:27 here. Unless she texted Bethany through Snap. Or she deleted it, right? After the fact of after she's talking to him. But I was like, nope, they already had the download. I was like, no. I was like, there's no text message at 4:27. There is none. There is no text message at 4:27. But she's looking at her phone. But she said she texted Bethany a last time at 4:27 a.m. before she went to Bethany's room. Dylan then explained when she first opened her door, and she said that she did not see anyone. Okay. Um, Again, she's looking at her text messages. She's not looking at Snap. Angel, don't make me take away your wrench right now. Okay. This is, if you're just looking at your text messaging, okay, you're just looking at your text messaging. Your snaps would go away if they're deleted after 24 hours. Your snaps sometimes are deleted right after the person views them. We are just simply talking about text messaging. She says the word text. She says she texted Bethany the last time at 4:27 a.m. She does not say Snapchat, nothing. Texted. You're looking at your phone. They say that she's looking at her phone. I'm telling you right now, we don't have any text messages off of the extraction. This is straight from the extraction. Then, if you go to she's like gonna talk about now this whole after she's talking about it, she goes, okay. Right here. Dylan then explained when she first opened her door and she said she did not see anyone. The second time when she opened her door, now this is all these opening and closings of doors, blah, blah, blah. But here she says the first time, nothing. Second time is when she opened up her door. She heard who she believed to be Kaylee crying. And Dylan believed Kaylee was in the second floor bathroom. She then heard a male voice, which she stated she had never heard before, say, "It's okay, I'm going to help you." Dylan believed the unidentified male was in the bathroom. And when the person who was crying, or with them, she believed it was Kaylee who was the one crying. Dylan stated that now that she has gathered additional information, what additional information? They haven't been told anything. The only additional information would be that she knows where people are in the house as far as where their dead bodies are. Okay. But wouldn't you as an officer ask, what additional information are you talking about that you gathered? From who? From what? What are you talking about? At the moment of hearing the crying, right here, she stated she believed it was Kaylee who was crying. Why do you keep writing this shit? She advised she knows the male's voice was not Ethan. I was like, yeah, I know. It's Stefan. Stefan's voice. Then right here, she described the last episode of Vampire Diaries as she remembered it was two males rescuing a female. She explained it was not violent. What? She advised the male figure in the last episode was wearing all black, but Dylan explained that that was normal for the series. She described the last She is not certain whether she heard Murphy barking during the first time she opened her door. What? See, now they're trying to get all technical. And I'm saying go and watch her in the body cam. She is not confused. She's go off of that. This is wild to me. But she does say that it's like, did you hear Murphy barking when you opened the door? But she advised it was possible he was barking but Murphy was moving away from the house. She described Murphy was a puppy, blah, blah, blah. That's not important. Okay, right here. Boom. She advised that she continued to call and text her roommates, but received no answer. She provided the times that she called and texted her roommates. And the time span she advised would have been between 4:20 a.m. to 4:27. And I'm saying, why is she stopping at 4:27? Why is she stopping at 4:27? DM texts Kaylee at 4:32 and 57 seconds. I believe that was deleted from her phone and she couldn't see that. She is literally saying that all of her stuff stopped. She's like, I texted all my roommates between 4 and 4:27. Well, if you're looking at your phone, you would see the last time that you texted people. DM texts Kaylee at 4:32 and 57. You would even just, what? I was like, that's weird. I was like, that doesn't make any sense. She advised that she never thought about an intruder. Then what did she think it was? And in her, why would she be so freaked out if it wasn't? That's why I'm just like, this is crazy. And in her mind, she stated she was not processing what she was occurring as a threat, as threatening. And I'm like, are you reading these text messages? They're both freaked out. Again, Dylan is not writing this report, you guys. Okay. And we saw how ridiculously different it was when we actually got to hear Dylan talking to the officer, right? On the body cam. So this is Blaker writing this. So until I am to hear the audio of Dylan's interview, I'm only paying attention to the stuff that he's claiming is she's looking at her phone and writing time stamping it. Otherwise, I don't care what Blaker wants to ascertain from what he thinks that she said. I'll hear Dylan myself and I'll ascertain what I want to ascertain from it. And you can do the same thing. But after seeing the body cam, if people don't realize that, wow, what transpired on that body cam is a hell of a lot different than what was written in a report. Okay. And Dylan didn't say that she just had woken up. Dylan said that she was getting ready to go to bed. Like, get the fuck out of here, man. Like, wild shit. But anyways, so also I'm of the belief that potentially somebody else could have been using Dylan's phone. Anyways, so she said that right here, further, she explained that Ethan, that she had tried to, Dylan further explained that she Snapchatted Ethan but received no answer from Ethan. She also texted him. Dylan thought that Ethan was still either at Sigma Chi or was at home. She was not certain. It's because when she went to bed, he was not there. And if you go off of what she's saying in the body cam, she went to bed right before 4:00, right? It's really significant. She doesn't know. That's why she's thinking that he's still at Sigma Chi. She wasn't calling him when she was doing all these calls. She's not calling him. Her first call is to DM calls Anna, DM calls Kaylee. DM calls Madison. DM text to BF then. But right here is where you get the whole breakdown that she's calling and yelling out their names while and before she sees the person. So okay, right here. Dylan further described him as being a taller, blah, blah, blah. She advised he had to have heard her call Kaylee and Xana, and she thought he would have had to have heard her calling for them. So both calling them and then calling for them. And she was confused as to why he did not come to her room. Now, that would mean, okay, if that is fact, okay, boom, boom, like I've said, she's making these calls. She's calling and calling for them prior to ever seeing the masked man, okay, which would mean she hears the noises. She's calling them, calling out their name and physically then using her phone to call, which would be at 4:20 and 4:20 and 20 seconds. Okay. And these calls take place before ever seeing him, which then lines up perfectly with when she says no one is answering to Bethany, because Bethany's the one that alerted everything to everyone, meaning her. And then she says, I'm really confused right now. And then she states, at 4:23 seeing him. And so the reason that this would be really, really important is because if you want to put the killer in that car that's leaving at 4:20 and 27 seconds or 47 seconds or whatever, well, there's a problem. There's a problem with the timeline based on Dylan. And I swear it looks more like I've said, that Bethany got the hell out of there. That's what I would have done. But let's go back over here. I would just think that as a trained detective for however many years, you would be saying things like, okay, do you recall, like, so while you're getting up, going down, getting up, not hearing anything, not seeing anything, okay, it isn't until the third time that you actually see the guy. You were making phone calls before you actually saw the guy? Yeah. Yeah, I was. Okay, so then this text, when you text her and say, no, it's like a ski mask almost. Is that right after you had seen him? Wouldn't you ask those questions? I mean, it's not that hard when she's saying that she has her phone and all these text messages. Okay, well here, let's go through this. So this is like you're texting this while this is happening. Wouldn't you get that information out of the person? Wouldn't you ask those questions? And when you'd be seeing, okay, wow, so you're saying when you were calling their names out and when you were calling them, yeah, this was after you heard someone running down the stairs and someone crying. Yeah. Okay. But you still hadn't seen the masked man yet. No. Okay. And then so then when you open up the door the next time, that's when you see the person. Yes. And while this is all happening in real time, you're communicating via text with Bethany, right? Yes. Or she's going to say, no, we just did all of that way after the fact. What? Oh, okay, way after the fact. You get like you're going to figure that out. You're going to be able to gauge all of this. But I don't understand why that you wouldn't ask these questions. But I just don't get it. But anyways, bottom line is that when you take this from the phones and she's using her phone and she's explaining everything, the car that's leaving at a high rate of speed cannot be the killer's car. That's all. That's all. That's all it's basically saying. That's all. And it looks more like somebody getting the F out of here. Like, that's what I would do. I'd be getting the F out. Okay. Now, let's go ahead and bring in. Boom. We're waiting for the live stream to begin here. Yeah. Again, that was an interview that was conducted. So you guys saw the 13th body cam. Then they took their phones and they downloaded them. And according to Mowry, they just never looked at them. They never looked at the downloads. He wrote up a report on 11:30 and said that he'll get to it when he can. Okay. All right. And so this interview was Idaho State Police, Vicky Gooch with Blaker. And it was on November 17th. November 17th. So November 16th, Bethany was interviewed by Idaho State Police. November 17th, Dylan was. So what is good, everybody? Welcome to Truth and Transparency. We are just waiting for Megan Marshall's actually holding this hearing. So and they are starting at allegedly, supposedly 1. So this is supposed to just kick on when they start, I guess. I don't know. Yeah, make yourself known. Make yourself known. Thank you, moderators. Give a shout out to Elbows Mom. Like it. Welcome. Membership. Cheers. Princess. Is it Amaria? Amaria? Mira? Amira? I like the name Mira. My niece. Oh, what's up, Jen? 29 months. Hello. Damn right, number 1 channel. Number 1 stunner. Cyber Ninja, welcome. I just see this keep popping up every day. Gifted 5 Truth and Transparency memberships. Yuri teaching us math. What else is going on? Oh, the Adelson case. Total, I mean, just wild over there. The dumbest dentist ever. Cardi B. Cardi B is just owning it, by the way. You guys know that Cardi B was getting sued for $25 million? $25 million. $25 million over a scratch on a nose that never happened. While she was just going to get her cooch checked because she's having a baby. Get out of here, man. How does that even happen? Wild stuff in the world. Can you imagine going to, like, I don't know, hey, these damn dentists. Montana in the house. Oh, here we go. I realized it was Zoom. Mia Batista. The guy up on the right corner. And the guy in the, I don't know who Andrew is, but.
All right, good morning. We're going to go ahead and go on the record.
Here we go.
Good morning, Your Honor.
Good morning. We are on the record here in Lake Talk County. This is Karen Laramie versus the city of Moscow. This also includes, and was recently amended in this matter, the amended criminal complaint that, the amended complaint in this matter includes Miss Laramie as original petitioner. It also now includes Stacy Chapin, James Chapin, and Maisie Chapin, all as plaintiffs in this matter, versus the city of Moscow as the defendant. This is CV 2925755. This morning here I have Mr. James appearing on for the city of Moscow. This is the time set in the matter. The court.
They're having issues.
That being for a permanent injunction that's being requested by the plaintiffs. I have reviewed, based upon stipulation in this matter, The court has determined that we will not be receiving any live testimony during this proceeding. The court will be relying upon the declarations that have been submitted in this matter and the parties' briefing in the case. The declarations are included to be that of Ms. Laramie, that of Ms. Stacy Chapin, that of Maisie Chapin, that of James Chapin. And then also the city had filed a declaration of Lori Hopkins. And so the court will be considering all of those as evidence in the matter, leaving though open for argument per the stipulation as to whether or not there are any kind of relevancy objections or any other objections to those declarations that need to be made by the parties here today. I do want to note that the court has reviewed in this matter all of the pleadings to include the original filings. I've also reviewed the response from the city that was filed on August 26th, and I've also reviewed the memorandum in support of the preliminary and permanent injunction that was filed yesterday on behalf of the plaintiffs. Before we proceed with argument in the case, I do want to note that this matter does concern the privacy interests of the family members for Ms. Madison Mogen and Mr. Ethan Chapin, as it relates to the investigatory records compiled and maintained by the city of Moscow in the investigation of these murders. This proceeding does not pertain to any other agencies that may have been involved in this investigation. At this point in time, the only defendant in this matter is the city of Moscow. Starting with Mr. James. Mr. James, were there any sort of objections that you had to the declaration that was submitted by the city in this matter?
No, Your Honor.
Mr. Plaskal, any objections on behalf of the city to any of the declarations that were filed?
No, Your Honor.
Okay, then I believe we can proceed with argument then. Mr. James, you may go ahead.
Thank you, Your Honor. May it please the court, Leander James, pro bono counsel for Jim Chapin, Stacy Chapin, and Karen Laramie. I will not reiterate everything that is in the briefing, Your Honor. I know you've reviewed it and carefully. I do want to touch on several subject matters and emphasize a few things. The subject matters are the facts of the case, the uniqueness of the case, and the application of the law to these unique facts. The facts. The city contends and has sworn testimony that it redacted all of the bodies in the case. We submit respectfully that that is factually inaccurate. Blood, as a biological fact, is part of the body. There are portions of these images that show, without any blurring, pools of blood, splattered blood, dried blood, smeared blood. Blood is part of the body. It is factually inaccurate to say that the bodies were entirely blurred. The blood, of course, most of it images of blood.
What the fuck is going on?
Your Honor has in the record, for example, in the testimony of Stacy Chapin, how incredibly harmful and emotionally damaging it is for her to see images of her son and the other murder victims. that are in these images that were released and that may be released. They're in there. They're just blurred. They're just harder to see. The city could have used a black box. They could have truly redacted, but the definition of redaction, which I put in the brief, is that all of the sense blur. It's not part of the court's analysis of why are they asking for this information. However, people who comment and look at this stuff say horrible things about the family members and others. So I think the context there is important, the uniqueness of the case. Application of law. There are two overarching theories that we put now, arguments we put in front of the court. One is the statutory right to privacy, and the other is the common law right to privacy, which is recognized in Idaho under the Urenga case. A few comments on the statutory right. I think one of the key issues under the statutory right is, there are others, but one of them is who qualifies as a victim. And the court can interpret the statute to determine whether my clients qualify as victims. Now, I think a reasonable interpretation is they do qualify as victims. They were victimized in two ways here. They were victimized first with the murder of their child and sibling that deprived them of the love and affection of the murder victims. It's tragic, and it happened. They were then re-victimized when these images, these gory images, were disseminated to the public, or at least in this case to one media outlet that then apparently disseminated to others because they're now out there everywhere. And my clients have seen some of these images, and the court has the record. It's been a devastating loss to them. They were re-victimized when these images were sent out to the public. I am respectful of the city, and am quick to add, I am not implying and do not mean to imply that the city had any intention to victimize these people. I do not think that. And my clients remain grateful to the Moscow Police Department for everything it's done. But in terms of analyzing who's a victim under the statute, I think it's relevant to recognize that my clients were re-victimized. And I think it's not a reasonable interpretation of the statute to determine they're not victims under the IPA, because it's consistent with other statutory, other Idaho code provisions that recognize the immediate family members of a decedent. They recognize that they have victim rights. In IC 195306 is the victims' rights statute, and it explicitly recognizes that family members have rights of the victims. The application of law here, I think, first of all, in conclusion of the statute, I think the clients qualify for protection from unwarranted invasion into personal privacy. They also qualify under the subsection small I to not be harassed by dissemination of this information. And again, whether intended or not, the dissemination of this information results in harassing them with emotional damage. So I don't think you can just analyze under subsection 2 little I. I think it's important to look at single I. Even if the court determines, which I do not think the court should, that, well, let me back up. Another reason under the statute why my clients here should be protected was laid out in the court's original analysis in the TRO and in the Gaylord case, which adopted the Gaylord analysis and supporting cases, including Supreme Court cases that recognize that when an individual dies, the immediate family members, the right to privacy of the decedent inures to the benefit of the immediate family members. And the court knows that analysis. The court has thoroughly gone through it. But that also applies here. So for all those reasons of the statute, I think my clients should be protected. Even if the court determines they aren't protected under the statute, which I think would be incorrect. But yeah, if that happens, there still is the common law right to privacy that's alive and well in Idaho and a basis for granting the injunction here. So in conclusion, and that right to privacy specifically includes intrusion upon the plaintiff's seclusion or solitude or into the private affairs. What is more of an invasion here of the parents and the siblings' seclusion, solitude, and private affairs than to disseminate death scene images of their children worldwide? The last thing I want to say on the statutory side, I want to go back to statutory because I meant to emphasize this, Your Honor. The IPA puts an affirmative duty on the city to, once a request is made, they have an affirmative duty within a certain period of time, depending on where the requester is requesting from. They have an affirmative duty to determine both what should be released and what shouldn't be released, what's subject to the exceptions. I understand that, well, that's the statutory scheme. That's what it says. It's plain language. The analysis of the city and by extension now the court is triggered by a request. And they're determined what is exempt and what isn't exempt under the statute. It is not triggered by an aggrieved individual under the statute coming forward and filing a lawsuit. That's not required. And my clients, and I believe that under the statutory scheme, this analysis is not just limited to my clients and the death scene images and their rights to privacy. They extend to all others who would fall under protection under both the common law and the statutory scheme. And I give the example in the brief. I'll just say it so everybody can understand where I'm coming from. Imagine a body camera video, a police officer entering a house, investigating a crime scene, and they run across a girl, a naked girl, coming out of a shower and happen to film it. Now, I don't think any of us would reasonably argue that that should be disseminated to the world. That girl has a right to privacy, and it shouldn't be disseminated. And under the Gaylord case, we use an objective analysis. Would a reasonable person see that as an invasion of privacy to disseminate their images of their naked body to the world? Yes. And it's an affirmative duty on the city in that example, were that to happen, to redact those images and protect the girl from the unwarranted invasion of privacy. So my clients respectfully submit that the analysis here extends beyond even their children and sibling, but to others, including witnesses and others. Now, implicitly, the city has acknowledged that analysis because they blurred images of the face of witnesses and others. So they've redacted, or again, it's not redacting, it's blurring, but they blurred certain things of other people, and I think that implicitly acknowledges what I've just argued. In conclusion, Your Honor, we respectfully submit that a permanent injunction should be entered, preventing any further disclosure of the death scene images, any further disclosure of the bodies, including the blood. That should all be redacted, any image of blood. And we would ask that the court also consider what other images aren't unwarranted invasion into privacy or an intrusion upon the individual's seclusion, solitude, or private affairs, because we think there are others there, but clearly the core ones that we think are over the line are the death scene images. Thank you, Your Honor, and I'm happy to answer any questions.
Thank you, Mr. James. Just a couple of follow-up questions here. So in your complaint, your clients seek a privacy interest in a number of different parts of the video, to include not only these, as we call them, the death scene images, but to include also the images of witnesses, the sounds or the audio related to those witnesses, any media containing the sounds of the witnesses, and what they may or may not be saying as far as just the sobbing portions, or them crying. So my question is, but then in your briefing, it didn't seem to address some of that. So I was wondering, at this point, are your clients still asserting a privacy interest in the images or sounds of witnesses? And if so, where is that? How do we get there as far as their privacy interest is concerned?
Yeah, good question, Your Honor. I'll answer. That links back to what I said about the affirmative duty under the statute. It's our position that the city, and by extension now the court, has a duty to analyze these images and these audio sounds to determine whether exemptions apply to those two. Now, clearly, those images and audio sounds are triggering for my clients and cause intense emotional stress. I think it is the question I think the court's getting at is, well, how is it an invasion of their privacy? And I would respectfully submit that's really not the analysis. The analysis is once the request is made, then it's the obligation of the city to analyze whether disclosure is an unwarranted invasion into the privacy interest of the person. That's why I gave the example of the naked girl. The naked girl, so to speak, is not here making a claim. No witnesses have come forward and made a claim. They don't have to. The statute asserts an affirmative duty. And so our position is that the city, and now by extension the court, because the court's now in the middle of this, it needs to analyze these images and audio sounds to determine what is appropriate or what is exempt and not exempt under the statute. And also there's the common law interest of right to privacy. I think that should be analyzed. And I'll just emphasize it. Nobody has to come forward and do what my clients did, find an attorney who would be willing to file a lawsuit for them and go to this extreme point of bringing a case. They don't have to. The statutory language is clear. The affirmative duty is on the city to determine what is exempt and what isn't exempt regarding all of the images. Thank you, Your Honor. I hope that answered the question.
Yes, thank you, Mr. James. And then the other question I have is that just before I turn over to the city and having reviewed what their briefing includes, if the court were to find that the family members here or the plaintiffs do not have a privacy interest, then do you maintain that the deceased individuals themselves have a privacy interest? And if so, to what extent?
This is a great question, Judge. I think under the Gaylord case and the cases I've analyzed, the privacy interests of the decedent still exist, but they inure to the benefit, as I said, to the family members to assert them, and they have a right to assert them. So I think that it's sort of how you slice it here. I mean, you could, I think, analyze it in a way to say that once the decedent dies, their privacy interests die with them, and the family members have a privacy interest. But I think it's fair to analyze it under the case law that the privacy interests of the decedent then are exercised by the immediate family members. So that would be the position I take, Your Honor, on the law, that to really refine it, there are really two privacy interests at stake here. One is the privacy interest of the decedent, that is exercised by the immediate family members, but they're also the privacy interests of the immediate family members.
All right, thank you. All right, Mr. Pascal, response.
Thank you, Your Honor. Your Honor has obviously reviewed our brief. I'm happy to answer any questions that you have about it, but I will be brief in my comments. I don't have a whole lot to say beyond what we have argued and laid out in our brief. I do have a couple of points I want to address that Mr. James raised, but at the end of the day, the city's the man in the middle here. If there were an option set forth in the statute that allowed these records to be fired into orbit, into the sun, I think, in my heart of hearts, and I'm pretty sure Ms. Batista's as well, we would just as soon not release these records. Nobody gets them. These are harrowing images. This was a horrific crime. I don't think that anybody could reasonably say otherwise. And I equally think that it would be difficult, if not impossible, to dispute that family members of victims of a crime as horrific as this, of course they are distressed, will be distressed, would be distressed by the release of any materials relating to the crime. I can't dispute that. I don't want to dispute that. And the city has not to this point and does not intend to dispute that. The declarations that Mr. James has filed on behalf of his clients lay out in sufficient detail that his clients will find the release of these materials distressing. That's not in dispute. The problem is the way the statute is written, at least as I understand it, and as I know Ms. Batista understands it, there's equally little dispute that the materials we're talking about here qualify as investigatory records under the Idaho Public Records Act. And there are several exceptions. There are several exceptions written to the statute. Existing case law says they are to be construed narrowly. And to the best of my knowledge, the only exception that has any plausible application to the materials we're talking about here is the unwarranted invasion of personal privacy exception set forth in, I don't have the code section in front of me, but I can pull it up in just a second. Should have had it in front of me, my apologies. Set forth both in Idaho Code section 74-124, and the definition of personal privacy is further defined in section 74-101 sub 17. And I meant to follow up on the court's second question to Mr. James. That is, I don't know, it might be the crux of the matter if Your Honor reads this provision and gives it its plain and ordinary meaning. It defines the right of, what is, who can raise this privacy interest in a fairly narrow and restrictive sense. I don't dispute that it was written against the backdrop of the common law, and I also don't dispute that if we go look beyond Idaho, the United States Supreme Court has discussed, what I understand at least. It's not entirely clear from Justice Kennedy's opinion, but I understand him to be talking about the common law right of privacy there, that the federal FOIA statute was written against as a backdrop. But the statute itself in Idaho is quite narrow in terms of the privacy interest that comes into play when you're talking about the right of privacy or unwarranted invasions of privacy for these purposes, for purposes of reading this narrowly construed exception to public disclosure of investigatory records, which again is required by statute in Idaho, for good or for ill. And I'm not going to go through what I wrote in my brief. Your Honor has it in front of, Your Honor has it. If you have any questions, I'm happy to answer. But the bottom line is the type of privacy interests that are talked about in Idaho Code 74-101 sub 17, they don't clearly apply here. The only interest that is talked about that might, I think, is, in terms of interests of deceased parties, it uses language that is not applicable here. And the other section that applies, or at least has plausible application, is the provision that talks specifically about unwarranted invasions as weighed. It imposes a balancing test. I don't know how you can read Idaho Code 74-101 sub 17 and not come to the conclusion that you can find a privacy interest. You can find whether it inures to the benefit of the deceased, the victims themselves, the family members, whether they are victims themselves as a matter of other statutory provisions or not. It's still a balancing test. Whoever, whether it's the city or a court that is brought into the mix, has to weigh the competing interests. And the competing interests are the interests in privacy, which, whether you find that the family members that have brought suit here have an interest in privacy or not, it still has to be weighed against the interest in public disclosure. And as I've also set forth in my brief, the city has received numerous requests for these materials. The city has received almost more than 1,150 total, and 250 of them specifically asked for images, body cam video, whatever. I may have the numbers slightly wrong there, but the bottom line is the city has received, at minimum, a couple hundred requests that cover investigatory records that include photographs, videos, whatever else the city's officers collected when they responded to this crime and investigated. Whether I personally, whether anyone personally thinks these images should be released or not, the city has a duty under the statute to release them on request, unless an exception applies. And as even Mr. James acknowledged, the city doesn't get to ask why. The city doesn't get to look into, quiz the requesting parties on why they want these images. And for lack of a better word, I struggle to understand why members of the public want these images, but I'm not the one who's made these requests. And equally, I unfortunately know that we live in a time when conspiracy theories, and as Mr. James referenced, the world of true crime, it's a big business, it's a big industry. Conspiracy theories run rampant, and as I cited in our brief, there are a small but vocal segment of individuals who, even after Mr. Kohberger pled guilty, admitted his guilt, admitted responsibility for these horrific acts, they still think that he might be innocent. I don't know what there is to say other than the reasons why any individuals would want these images. It's difficult for me to wrap my head around. But that is, unfortunately, under the way this statute is provided and written, that isn't the question. The question is whether the public has a right to look at the affairs of its the public officials that run the government, investigate crimes, and prosecute crimes. There is no investigation ongoing. The city can no longer say, look, we can't release these. There's an investigation ongoing. It will impede the administration of justice. for good or for ill, the materials have to come out unless an exception applies. And the only exception that applies here is one that requires a balancing test. And as far as I can tell, the city applied that balancing test to these images and crafted what I think is the only sensible balance. The materials that the city has provided to the court, the initial redactions, Mr. James characterizes blurring of images as not redactions. I don't know how exactly to respond to that. If they're not visible because they're blurred, or if they're not visible because there's a black block over them, if you can still see the rest of the room, that seems like a fairly trivial distinction. If the court intends to issue a order that requires that black boxes be imposed instead of blurred images, Ms. Batista can correct me if I'm wrong, but I think that the city would be probably amenable to that. I don't think that that is a hugely burdensome issue. Whether other parties that have requested the images would object, I don't know. The city could end up back in front of Your Honor or in front of some other judge in this district saying the flip side of this argument, which is to say, well, blurring is good enough. Why didn't we get the blurred images? Why do we have to look at black boxes or something similar? As I said, the city is in the middle here. The city is going to get it from either side, and there doesn't seem to be any way to avoid that. As far as Mr. James's suggestion that images depicting blood spatters or blood pools are body parts, I don't know. I don't have a particularly, I don't know how to respond to that, simply put. If I'm cut and blood ends up on the floor, I don't think that is part of my body anymore. I know that there is a fairly extensive body of intellectual property law that gets into residual interests that individuals have in, for example, blood or DNA once it's removed from them. But to say that images of blood spatter is tantamount to and no different from a depiction of a dead body on the ground, I don't think that's a strange argument, and it's not one that I agree with. I don't know how exactly to respond to it other than to say I don't think it's accurate. I don't know how much else I have to say, Your Honor. At the end of the day, we are talking about an exception that requires public officials to conduct a delicate balancing test and weigh the public's interest in disclosure and the interests of family members or the deceased, depending on who exactly it is who holds the privacy interest, and release the materials that the statute requires to be released. I think the city did that here. If the city came up with a balance that is not completely where the court thinks it should be struck, we will accept your guidance. I mean, I don't think that there is necessarily anything in the statute that says one way or another whether a public official's application of this balancing test is due any discretion or due any deference. At some level, it's inherent in any type of judicial review of administrative or agency actions. But I mean, we're not here on a petition for judicial review. We are here under a request for injunctive relief or I guess declaratory relief of some sort. And the statute doesn't provide any clear guidance. I would simply say that the court should, just as a matter of principle, defer to the considered judgment of public officials in this area. But at the end of the day, weighting evidence is something that the court is very familiar with. That's what courts do on a daily basis. Whether that means that every particular decision made by the city in this case or any other case in terms of disclosure of investigatory records needs to come in front of a judge to be reviewed and ratified, I don't know. That doesn't seem like the scenario that the legislature envisioned, but perhaps it is. And I'd just like to conclude by saying that Mr. James suggested that this is in some sense a unique case. I don't think that's necessarily true.
It's not.
I think, unfortunately, a lot of the interest that he was referencing, the fact that the internet means that disclosure instantly makes whatever is released, it's around the world before the opposing party has their boots on. I mean, Your Honor is aware that my office was brought into this case very late. I wouldn't even say late. The process has been ongoing. We were brought into the case right before the lawsuit was filed. I've since reviewed the images. I've since reviewed the body cam videos, both in the initial redacted form prepared by the city and in the additional redacted form prepared by the city after the TRO was issued. This is not an easy case. I think Ms. Batista and the city did an excellent job in coming up with a workable balance, the most workable balance that could be struck under the circumstances. And it is unfortunate that the release of these imagery, it's unfortunate that it will make it onto the internet. It will be splashed across news articles, and it will cause the victims' families distress. That, unfortunately, is what the statute seems to require, at least as I read it, and at least as I understand the facts at issue here. Maybe this is maybe the statute to be changed. Maybe the Idaho Supreme Court has to clarify the interpretation of it. I don't know if this dispute is going to be resolved here simply by virtue of the fact that we are talking about a statute that seems to have perhaps unintended, perhaps intended negative effects when we're talking about murder investigations. And I mean, I think I cited this in my brief, but some other jurisdictions have laws that specifically, it would appear, address this exact scenario where investigatory records, whether they involve murder investigations or not, they are generally not subject to disclosure. They're very limited. Pennsylvania has a statute that does this. Idaho, for good or for ill, does not appear to. We are simply, and by we, I mean myself, my office, and the city of Moscow, are simply trying to deal with the competing interests that the statute has created and do what we can to balance the public interest in getting sunlight being the best disinfectant versus the very understandable concerns of any number of families of the victims. And so, Your Honor, if you have any questions, I'm happy to answer them. And I would also point out that if Your Honor needs additional time to craft a ruling, if Your Honor needs additional briefing, Ms. Batista and I have covered this previously. We would be happy to leave the temporary restraining order in place for a limited period of time, simply to allow any additional briefing that the court considers necessary, or simply to allow the court to make a informed, full, and reasoned decision. So just throwing that out there. But if you have any questions, I'm happy to at least attempt to answer them.
All right, thank you, Mr. Bliscow. I do have a couple questions. So the city, as I understand it from the declarations that were submitted, has responded at least to 2 different requests for this information. The first of the photographs that were blurred, the city did that that was prior to this case being filed. The city took it upon itself to blur the faces. It redacted personal information for witnesses and other non-law enforcement individuals. They blurred bodies. They blurred photographs within the rooms and other items within the rooms. And then also VIN information on a number of vehicles, license plate numbers, including 4 vehicles that belong to the victims, or the deceased, I should say, in this case. The reason I believe it's incumbent that we use the term deceased as opposed to victims is because there are other victims in this matter. And I think that being identified as far as the criminal proceeding goes, and how that definition applies across whether it's a constitutional protection for those victims that are named, but also under Title 19 that both counsel have pointed to. So one of the questions that I have that is in responding to those requests, initially, and then also subsequently after the temporary restraining order was issued, which at that point, was very limited in what this court issued. That being that the city was restrained at that time from releasing any additional audio, video, or photographs or images concerning or related to specifically Madison Mogen's bedroom, no one else's. The city then released a body cam video with utilizing black boxes over all of the bedrooms within the home, not just the decedent's and not just Miss Mogen's as was ordered by the temporary restraining order, and also muted certain audio within that. So my question is for you, the city has to justify, obviously, as you know, under the Public Records Act, the city has to justify those kind of redactions when it's responding to a request. What was the justification for that, or what statutory basis did the city use to respond to those requesters and say, this is why we are blurring these images?
My understanding, Ms. Batista can correct me if I'm wrong, but my understanding is that we relied on your order, and the fact that Mr. James had indicated to us that he was intending to bring claims on behalf of other, and I apologize for the imprecision in my usage of deceased and victim, Your Honor, but my understanding is that the statutory basis, I don't know if there's a specific statutory basis that the city relied on other than to say, we have a court order that says we can't release bedroom imagery of this victim. We have a plaintiff's counsel who has indicated that additional parties are coming. It was abundance of caution. I think that if we had gone the other route and simply redacted Miss Mogen's bedroom with black boxes and nothing else, I'll be frank, I would not want to be back in front of Your Honor arguing and explaining why, when we knew additional plaintiffs were coming and were going to be added, and as it turns out, only one was, why we defied, if not the letter of a court order, but why we defied the spirit of a court order that clearly had found that bedroom imagery was potentially problematic. Rock in a hard place, Your Honor. That was the basis on which we released that body cam video with those particular redactions of all of the bedroom imagery or any descriptions of the bedrooms. Again, Ms. Batista can correct me if I'm wrong, but that is my understanding of what the basis was.
But I guess I'm asking, before any court intervention, the city released images to, as we know, KTVB, I believe was the requester, that have been disseminated. I don't know who or how. I know that's not even part of the analysis here. It doesn't matter, but they are widely available on the internet. Though the city made a decision at that point in time, based upon their statutory duty to respond to a public records request, that they were going to blur certain things, which I went over. There was no court order in place. What I'm wondering is, what was the city's justification? What were they using to justify that blurring or redaction of the images at that point in time? Was it this provision, the unwarranted invasion of personal privacy, or was it something else?
Ms. Batista, you're on the call. Would you like to address that?
It was based on the unwarranted invasion of personal privacy.
Okay. So then my next question is, if that was the case, whose privacy interest was the city asserting? And was it that it was an unwarranted invasion of the personal privacy of the deceased person themselves? Or is it of the family members of the deceased? Do the deceased individuals maintain a privacy interest in their body, their blood, their effects, their personal identification, the VIN on their vehicles, the license plate numbers on their vehicles, because those were blurred. So is the city maintaining then if the family members do not have a claim or a privacy interest under this particular exception, is it the deceased person? And how far does that extend, Mr. Pleskow?
Well, I think that, we're getting into an issue that Mr. James got into as well, which is whether and to what extent there is an attendant interest beyond what the deceased has. I think that there is undoubtedly, whether in Idaho or elsewhere, a common law privacy interest. Favish, the United States Supreme Court decision, talks about that, at least in general terms, maybe not specific to Idaho. But I don't know is the simple answer, Your Honor. It is difficult to say. The statute that defines what an unwarranted invasion of personal privacy is seems to suggest that it is a narrow interest that endures to the benefit of the deceased only. That's the only one they're talking about there. There's no mention of family members. There's no mention of other interested third parties. And yet, you can look to other provisions of Idaho code and find language that seems to suggest that victims have some sort of interest that might apply here. I think that the court has to go by what the specific statute says here. Specific derogates from the general. The specific provision we're talking about here is the specific statutory language that governs the release of public records. And to govern the release of public records, this statutory provision talks specifically about what is an unwarranted invasion of privacy and not. And that's the term you have to look at. Looking elsewhere to terms that are not referenced, the legislature could easily have cross-referenced these statutes and said, this is what it is defined as for these purposes, subject to the limitations set forth in statutory provision X or Y, or in addition to the provisions set forth in statutory provision X or Y. That's not what the statute says. That might be what it should say, but that's not what it says. And to the extent that we are talking about the redaction of private information of what would be like VIN numbers, other personal identifying information specific to the deceased, I wasn't involved with the initial redaction process, so I will freely admit that I might have to turn it over to Ms. Batista on this because I hate to throw her into it, but the exact basis on which these were released is she is much better versed in the analysis and the thinking process that went into that. So, Mia, if you would like to address this, if you can address this, please do. Otherwise, I will attempt to muddle my way through the city's thought process.
Your Honor, if I understand part of your question, it was, involving the redactions of the vehicles in the parking lots and the VIN numbers. There are sections within the Idaho Public Records Act that allows you to redact personal identifying type of information. When reviewing those, we felt, in part because of the way these materials were being shared nationwide, really, that not knowing exactly who those vehicles belong to, what could be done with that sort of information, we erred on the side of trying to protect whoever the owner of those vehicles would be, trying to protect their privacy interest. And that's why we redacted those. I'm trying to find the exact section, but I'm not able to find that right this second. But there is a section that allows you to redact personal type of information, identifying information that would include things such as, financial account numbers, social security numbers, driver's license numbers, certain information within a driver's license number, and things of that matter.
So I guess another question I have then, going on this same line, is that if we are to interpret the statute as Mr. Pleskow, as you've indicated, and following your briefing, and saying that it doesn't specifically say that the family members have an interest, a privacy interest. In subparagraph 17A, Roman numeral 2, it says that the disclosure or release of information is likely to violate legitimate and substantial privacy interests of the person identified when such interests are weighed against the general public information. If Mr. Pascal or Ms. Batista, if the court limits the interpretation of of the person identified being the decedent themselves, then, and the city were to release images, video, not blurring, not redacting, just showing the dead bodies, what's the recourse? The decedent person doesn't have, they're not here to challenge that. So who then on their behalf but the family can? I mean, what's the point in having that particular subsection of unwarranted invasion of personal privacy if it's left to the decedent to try to come forward to claim some interest in saying you can't release an image of my dead body? I mean, that doesn't logically make sense. So I'm trying to understand how we can be so narrowly interpreting it if that's what the city is asking.
Well, for one, this may be splitting hairs here, but estates of deceased individuals have residual interests. The mere fact that a family member can't bring a claim on behalf of a deceased, but the estate can, is not a concept that is utterly alien to law, whether in Idaho or elsewhere. I think it might be unusual to interpret, a right of survivorship in this context that does not inure to surviving family members, but does to the estate.
So, sorry.
And it's not completely unprecedented.
I'm sorry to interrupt you, but are you saying then that what should have happened is that these families should open up a probate and be representatives of the estate of these two individuals, or in order to come and assert? I'm confused on what you're distinguishing.
I mean, yes, I think that is the distinction that I'm drawing, simply to say that if it's a personal representative of the deceased estate bringing claims, that is the answer to your question. I don't necessarily think that it's an unusual result. I will freely concede that, and it may or may not be what the legislature intended. But at the end of the day, it is what the statute says. And I mean, that is where we come down, and unusual, unorthodox, strange though it may seem, that seems to be what, in our view, the statute suggests.
Okay, and so if the court does find that these particular plaintiffs, have a privacy interest, does the city agree that the other deceased victims' families would have a similar interest? Or does the city believe that they should be required, as Mr. James has done here on behalf of two of the decedent's families, filed a suit to assert such interest?
I think that I can only answer the claims of the parties that have filed suit here, but as a general principle, I don't think there's much difference. Yeah, if one set of family members have a privacy interest, so do all. And I mean, there's a reason why the materials, the additional redactions the city has prepared, apply to all bedrooms. So go one, so go all. It's the same thing. And I don't necessarily think that there is any reason why, at this point in this litigation, a separate suit would have to be filed by the additional family members. If Your Honor says there's a privacy interest here and it weighs strongly in favor of X or Y, the city is going to abide by that ruling across the board here. It's not going to sit here and play games and say, well, two families have brought suit, but the other two haven't. So these images can go out, these images can't, and too bad you didn't file suit. I think that we do not dispute.
Oh, God. Hold on.
interests. 4 families haven't. 2 images get released, and the other 2 don't. There's no difference here. We will abide by your ruling, whatever it is, Your Honor, subject to potentially appealing it.
Okay. And then, so my last question, Mr. Pascal, sorry, I do just have one more. So the city has asserted, obviously, that the public has an interest in law enforcement's investigation. That is the primary interest that we're weighing against this privacy interest, and whether or not the release would constitute an unwarranted invasion of that personal privacy, as opposed to, say, a warranted invasion of the personal privacy. The videos depict law enforcement's actions, as we know, as far as going into the scene and those things, as well as the written reports that the city has already released or made publicly available on the website. So I am wondering how that public interest is enhanced with images of the bodies, the blood spatter, the blood stains, when all those descriptions are available in reports. How should we weigh that, or the court should weigh that against the privacy interest? I guess I'm wondering, what is the threshold the city sees as the unwarranted invasion as opposed to just a warranted invasion?
I mean, Your Honor, at some level, as we set forth in our brief, it is difficult for us to answer that question. We aren't the party that wants it. It is difficult for me on a personal level to understand why imagery, body cam videos, and what have you, why they are necessary, what clear, legitimate interest their disclosure serves. I'm not the requesting party. The city has 200 of them lined up. If we turn around and say, we draw the line somewhere, it might satisfy some of them, it might satisfy all of them. I don't know. The city might end up defending several lawsuits from parties that are interested.
Yes, they will.
Think that the precise imagery that you have just listed off is utterly essential, whether because they have questions about the investigation, whether they have questions about Mr. Koberger's guilt, whatever the reason may be. We can only speculate as to what that might be, or whether those lawsuits will be filed. At the end of the day, a line had to be drawn, and our understanding is that where warranted and unwarranted lie here, it doesn't end at the edge of one of the deceased's bodies, but it's kind of close to that. Crime scene photographs that show dead bodies are clearly an unwarranted invasion of personal privacy. There's a Supreme Court case that says exactly that. Justice Kennedy talked about it at length. We do not dispute that. However, body cam videos, photographs, other records that were compiled during the course of the investigation that are careful to omit imagery of the bodies themselves, that show how officers processed the scene, that showed how officers investigated the crime, and that dispel beyond, in my view, any possible basis to question that this was a properly run investigation, and there is no reason to doubt the guilt of the party who has admitted that he committed it. I think that it is nothing short of conspiracy theory that gets into why these materials in any form redacted, any form greater, I should say, than, all right, let me back up that just a second. I do not see how anything other than conspiratorial interests would support the release of imagery and body cams beyond the version the city initially prepared and that initially provided to the court for its review. I also don't see how the city can reliably stand up in front of a judge, whether it's this judge or another court, in an action brought by a requesting party saying, we need this imagery. We think that it has these redacted photos with these black boxes that the second set of redactions prepared by the city or something in between. We don't think this is enough. We think these are investigative records. We think we need them to prove or disprove what we think are our understanding of how things went down. Bottom line, as I said, Your Honor, a line had to be drawn somewhere. And if the city came down slightly on the wrong side of the balance, I don't know what there is to say other than we will accept Your Honor's assessment of where the proper balance lies. We might appeal it. We will, however, comply with it. And we are talking about, at the end of the day, concepts of warranted and unwarranted. Your Honor has been on the bench for a long time. Warrants, reasonable suspicion, Fourth Amendment. These are not standards that are amenable to mechanistic, clearly defined, easily applied in all circumstances definitions. Courts have been wrapping themselves in knots since the beginning of our country, trying to define what is reasonable suspicion, what is probable cause, what is a warranted intervention, what is an unwarranted intervention. And I don't know what else I have to say other than we think the line was appropriately drawn by the city in this case in the initial set of redacted photographs and videos that it released. If Your Honor disagrees, we will move from there.
All right, thank you, Mr. Glasgow. Mr. James, any reply?
Your Honor, Your Honor asked some very good questions there of all of us. And I think it's important to look at what the city did as opposed to now necessarily what it's arguing. Before all of this started, the city released to KTVB these images and redacted the bodies. And they redacted well, I should say they blurred, to be consistent. They blurred the bodies. And why did they blur the bodies? In their view, it was redacting the bodies. And why did they do that? I think one can reasonably infer the city did that because they believed the exceptions within the statute applied. That's why they did it. And Mr. Pascal has candidly just admitted that, under the Supreme Court analysis, that the Decian images are an unwarranted invasion into personal privacy. So I think, look at what the city did. It followed the statute, it thought, by redacting those images, which means the privacy, it's an unwarranted invasion of personal privacy to show the images. The question then becomes to whom. We would assert both for the decedent and for the immediate family members. But the reality is they interpreted the statute the way we're interpreting the statute. That's why they did that. Now, the subsection of the statute and the relevant language, the city argues, you need to follow the statute, but what they're really arguing is you need to follow our interpretation statute. And the court ultimately needs to determine what these words mean. But the term used in the statute is somewhat ambiguous. It says disclosure or release of information is likely to violate the legitimate and substantial privacy interests of the person identified when such interests are weighed against the general public information. So what does the language of the person identified? Well, one can interpret that to mean the person identified is the person whose privacy interests are being violated or coming forward. And that's reasonable. I'll illustrate why. But this doesn't just apply to images. There could be a person who's in the image that is not the decedent, and it's like the example I gave of the naked girl. It's an unwarranted invasion into their privacy, and this is the mechanism for them to assert it is it's an unwarranted invasion on the person identified, and it could be a person who's not the person the picture was taken of, whose privacy interests are being violated, is my point. And probably the girl example isn't the best, but there are situations where there could be information that's disclosed that shows one person, but it violates the privacy rights of another, maybe the wife or husband, a disclosure of certain images or information about their spouse may be an invasion of their privacy too, and they have a right to assert it. So I think the court can interpret that statute to apply where the privacy interests of the person identified are the people identified are the people bringing the claim here. And also, I just remind us not to forget that there's a common law right of privacy out there, which standing alone, I think, is a basis to grant the injunction. So thank you, Your Honor. In sum, I think the city's actions already answered the central question here. There is a privacy interest. There is an unwarranted invasion. The real question gets to be this balancing test then. And I think that's where Mr. Pascal was going when he said several times, in end of the day, you really get to this balancing test. And I'll just say a few words on that. There is a balancing test, and we recognize the importance of transparency in government, and we recognize the importance
No, you don't.
of the policies underlying the statute regarding disclosure of information that's not subject to the exceptions. And we understand that. I will contend this is a unique case with the worldwide attention, and because we're at an inflection point in technology and an inflection point in this true crime phenomena, that has all collided to make this, I think, a unique case. And how that fits into the analysis, I think, is something for the court to consider. But when you look at what these images would show, the dead bodies, I mean, what more do we need to know? The autopsy reports, for whatever reason, are already out there. If you want to know how many times each child was stabbed, just go read the autopsy reports.
You don't have them.
They're circulating everywhere.
Where?
If you want to know how gory the scene was,
What is
you
he
can read all
talking
that.
about?
I think that was partly what the court was looking at. And so the questioning is, this information is already available out there. Do we really need to put gory images of bodies and blood, which is part of the body, no matter how that's argued, it's part of the body, to put it out there in the world? Under the unique circumstances of this case, no, because there's already so much information out there. You can find this stuff elsewhere without having to look at these images.
Oh, shut up.
So in conclusion, Your Honor, I think the city has already admitted that the statutory unwarranted invasion of personal privacy interests apply, because they've already interpreted the statute to redact images before any of this got started. And the question then gets to be, where's the line for the court? And I think the court has already found that the death scene images are over the line. We think some audio and some other images are over the line. And we respectfully ask the court to enter the permanent injunction. Thank you.
All right, thank you, Mr. James. All right, thank you, counsel, for your submissions, including the briefing on this. I am going to take the matter under advisement and issue a decision. In the meantime, the temporary order that is in place specifically was in place until an extension is granted or the order is vacated upon further hearing. The temporary order will remain in place pending the court's decision. I am going to issue an amended temporary restraining order, however, because the original order did just prohibit disclosing any images, audio, or video depicting the inside of Madison Mogen's bedroom. Given the additional plaintiffs in the matter and the city's agreement at this point in time, based upon the argument presented in answer to the court's question, that if the court does find there's a privacy interest ultimately for these families, that privacy interest would extend to the other, at least decedents, victims' families, without filing a suit in the matter. I'm going to just extend the temporary restraining order to include that there wouldn't be any disclosure of images, audio, or video depicting inside of Madison Mogen's bedroom, I am going to say at this point in time, of the Madison Mogen's bedroom, Haley Gonzalez's bedroom, which was also black boxed at one point in time. And then Xana Kernodle's bedroom, in which Mr. Ethan Chapin was located. At this point in time, just so that there aren't any additional release with those things until we can get at least a final decision here. Quite frankly, I think the court has made clear in its temporary order decision that was issued on August 15th that I think we are really looking at the death scene images, whether or not those should be released, and if so, to the extent of which, whether they're blurred or otherwise redacted, what that is going to look like so as not to cross the threshold of the unwarranted invasion that's being asserted. But again, I thank council for your time here this morning, as well as your briefing on the issue and the declarations. I will take the matter under advisement and we will be in recess for today. Anything further, Mr. James, in this matter?
No, on behalf of my clients, we thank the court for the judicial guidance the court has provided and the riveted attention the court has given to this case and the expedited nature of the case. And we are grateful that the court, however it comes out, we are grateful for the court's judicial guidance.
Right, you're welcome. Thank you, Mr. James. And Mr. Pluscal, anything else on behalf of the city here today?
I would just like to thank you as well for your time and your attention to this matter, Your Honor. And that is all. Thank you.
Thank you. We will be in recess.
All right, there you guys have it. They're going to be in recess. All I have to say is I think this could potentially divide the families again. I want to think about some things. I just know what the statute is there. I know that you just can't go and just do whatever you want just because, hey, it sucks, but families don't want to see something. That's just not good enough, though. And you know, I think is really, really interesting is that why didn't anybody from the media? Nobody from the media got involved with this. Nobody from the media. Like, people will piggyback people's, like, the case or be like against it or whatever. Nobody piggybacked this. So I want to look into some stuff. But it's one big club and we are not in Atlanta. Oh gosh. They're asking for a permanent. You guys know what the word permanent means? Permanent. Ain't happening. Permanent. Yeah. Okay. Media's gonna piggyback that appeal, maybe. So I don't know. But let's go ahead and I got some information that I'll bring to the attention a little bit later tonight. Thank you guys for joining. It was nice to see Birdie in chat. I'm gonna be with Birdie. Is it okay if I tell them, Birdie, or is this a surprise? I'll wait for Birdie to old Kohlberger it up there. I just know that Steve Gonzalez wants transparency. And I don't know how. I don't know. Yes? Okay, good. Next Tuesday night, I'm going to be over on Birdie's channel. We're going to be doing a show. So join us there next Tuesday night. What time is it? 7? Is it 7 Eastern? So, yeah. It's next Tuesday night. Let's go to the hive. And he's just going to hive us all with his conspiracies. Because that's all they kept saying on this thing is all these conspiracy theories out there. Like, it's like, what are you talking about? They didn't make the FOIA. Freedom of Information Act didn't come because of conspiracy. Okay? The Freedom of Information came from the fact of, like, because, I don't know, I'm putting out a lot on my channel of just, hey, why did this get drug out for 2.5 years? It seems like a lot of people made a lot of money and did all this stuff. And then, oh, okay. We all made a bunch of money. We got a bunch of government grants and shit. And then a lot of people got paid a lot of overtime. Okay. It's just crazy. You know, like, just then you're at the last minute not going to, if there's a case that the death penalty, this would be it. But hey, let's just go deal with the devil. And a case that should go to trial doesn't go to trial. And we're just going to shut everything down. I will say that I think it's great that the police and stuff have been putting out their reports. I think the FBI, they did the most of the work. I've read every single report. The FBI, what I'm talking about, they did it all. So FBI, release your shit. Pullman did it. WSU, get on the website. Don Daniels, release your shit. FBI, release your shit. But I'm sorry, this case is not different than any other case, other than the fact that why didn't it go to trial? It was marching all the way up to trial date, and then this just happens. But that's where I would think it's different than other cases that, you know, you go 2.5 years and literally on the eve of trial, you know, you don't have that. You got literally the families. So you got people praising Moscow Police Department. They're just the best. And the Latah County Sheriff's and the prosecutor's office, they're just the best in sliced bread. And then you have the other families that are like, they fucking suck and they are shitty. And so it's like, wow. And then you come to find out, well, oh, the people that aren't too proud of the way everything was handled, oh, their kids were no longer in the sororities anymore. And the people that are loving how everything was handled, oh, their kids are still part of the Greek fest, you know? Just things to point out. And that, you know, we're just not playing by your rules. Like, transparency. Redact some stuff that needs to be redacted. And I just can imagine that. You hear what they were arguing about? There's cars on the street that people are just like, oh, we're gonna redact this. This is who, what? Or we're gonna just put a little black over something that's on a wall that has to do with eyebrows, some fucking magazine cutout. You think you're gonna be able to put a black blob over a magazine cutout? Have you all lost your minds? Why are you redacting that? What are you doing? And now you're talking about redacting blood on a wall because blood is part of the body? Well, I'm going to church right now because I'm going to have some blood of Christ and some body of Christ, you know? I'm going to go get my communion, man. And I'm going to go drink the blood of Christ. And I'm going to go eat my communion wafers, okay? Like, come on. I just can't even. And then they were talking about true crime people. And I'm like, wait a second. The Chapins are over here going to CrimeCon, going down to Othram, blasting it all over the internet about how great this fucking investigation is. And I'm over here like, yeah, let me see what you're talking about, because I see a lot of how the fuck did you get to Brian Kohlberger? Not that he's not the guy, because he said he did it. Great. Awesome. I think that you should believe him. I'm over here just like, wow. Maury's over here saying he didn't even look at the fucking phones. Jesus. And then you were trying to trap Jack Showalter. You were trying to trap Jack Decor. Okay. And that's all I see is just like, fuck, man. You lie. Like, there's a lot of violating of constitutional rights going on in this case. Brian Kohlberger said he did it. Awesome. You should probably believe him. I'm talking about, holy shit, what are the feds doing? Holy shit, what are these agencies doing? Wow. But no, I don't want to. This guy talk about people. I don't know why people are even requesting this. I think that I'm very respectful about what we put out on the channel. I would not be putting out dead bodies unredacted on this channel. I would tell you to go watch it yourself. Go look at it yourself. Okay. But to have somebody like a Scott Roeder explaining, okay, to people how and what a crime scene looks like, and to accept what has gone on, and this is this, and this is this. Well, how about I'll tell you another reason why you should probably question everything. Do you guys know who Sullivan is? They didn't get a blood spatter expert on this case until right before they wrecked the house down. They brought out, and I'm going to talk about it later on. They looked at everything in 2024. When did they turn down the house? December what? December 23? Whenever they tore down the house, They had homegirl in there right before that. You guys know that? I'll tell you all about it. They didn't get an expert in blood spatter until way after the defense, and they didn't look. The person that looked at it and did everything with the house and consulted with did it right before they wrecked the house. It's in a report. We can talk about it. And I'm just like, so that's like the Delphi case in 2017. They didn't bring out somebody until Richard Allen had their people looking at it, and then they went and consulted with the blood. Wait, you guys have had this case for how? What? That was a Delphi case. Then this case. So who's the? I just can't even. And you know why they had to go get somebody, right? Is that right? Because of what they were saying. This was a cleanup. That means that the person would have actually looked at the house, who's the consultant, is after all of the chemicals would have been in that house. But after the defense is saying multiple perpetrators, multiple weapons, staged cleanup. So we'll talk about it. Thank you so much. Yeah, December 25th. Yeah, I'm saying what was this year? So this year's the 2025. So they wrecked down the house in 2023. Like, I think a year and a month later. Okay. See you guys on the flip side. Remember, next Tuesday, mark your calendars. I'll be over on Birdie's channel at 7. Thank you, moderators. Thank you, subscribers, members, lurkers. Thank you, guys. Mousy, keeping transparency, full the conspiracy. Yeah, I cannot believe that they were on a call talking about conspiracy the whole time. I cannot believe, and they were talking about true crime people, and I'm just like, oh my God. But yet here, they're just teaming up with the James Pattersons of the world and writing books. Are you fucking kidding me? I can't. I gotta go. I gotta go to church. I gotta go pray for myself. I gotta go to confession, because I'm just gonna say motherfuck the whole time. God, this is crazy. What I was listening to. Okay, I'll stop.